Good morning. We're here in Baton Rouge, Louisiana, capital. We're 400 feet above the Mississippi River. When a state chooses to enact its own alternative legislation and then substitutes it for the provisions and guarantees of the Constitution, that would be an illegal and unconstitutional act. It would be the crime of sedition. Sedition is defined as the speaking or writing words such as law established in order to cause disaffection to the Constitution to procure its alteration in an other than lawful manner. There's one way to change the Constitution. You can find that within Article 5, the special amending procedure of the Constitution, and it does not come by way of a state imposing its will upon the rest of the nation. Thomas Jefferson said that federalism is not a single state or small factions of states imposing their will upon the nation, but instead acting as the aggregate and an essential buffer between the central government and the people. You see, when the state of California enacts its own alternative legislation in its constitution, inferior constitution, such as they did in 1884, that allows for the prosecuting attorneys to charge by way of information, not by indictment, as required by Clause 1 of Amendment 5 to the United States Constitution, that would be a seditious act, because it is altering the Constitution in a manner other than what's obligated and required within the Constitution. So states cannot enact their own laws that are contrary to the Constitution and then begin to enforce those, because that would mean that the state laws are more powerful than the Constitution of the United States, and that's not true. None of us believe that. The Constitution of the United States is the only thing that binds America together. The only thing that attaches Louisiana here to California is the Constitution, because the only thing that makes America America is American laws. So failure to follow and obey those laws means that we don't have a nation anymore. We don't have 50 autonomous sovereign states that are able to act independently, whatever way they see fit, and treat the people however they decide, because that's not the Union. That's not America. This is not the United States of Louisiana or the United States of California. This is the United States of America. We need to understand that what makes America America is American laws. So failure to follow them and adhere to them would mean that we no longer have an America. So the state of Louisiana, just like California, has decided they're going to permit their prosecuting attorneys to charge by way of information, not by indictment as required, according to Clause 1 Amendment 5 to the United States Constitution. When those prosecuting attorneys choose to rely upon that inferior state law to deprive a person of right guaranteed by the Constitution of the United States and break the oath that they took with them to the Constitution of the United States, they just committed a crime. It's Title 18, subsection 242, Deprivation of Rights under color of law, which states any person who, under color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. This is a per se crime, meaning we don't have to prove they intended to breach their obligation. Simply by virtue of the breach, all elements of crime have been met, because their willfulness and knowledge derives from the promise they make. Now, when that prosecuting attorney commits that crime and brings the incorrect charge and instrument and to the judge and asks the judge to hold someone over for the infamous crime without having the proper document, that judge has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon the prosecutor's abuse of discretion, then he himself is abusing his discretion. And now you have the crime of conspiracy to deprive rights, Title 18, subsection 241, that has been established by and between the judge and the prosecuting attorney. Once that judge orders the accused to be held over for the infamous crime without having the proper documentation in place, and he hands that order off to an officer and asks that officer to go out and perform an arrest, that officer also has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise his power based upon someone else's abuse of discretion, then he himself is abusing his discretion, and now you have him implicated within the criminal conspiracy as well, due to his negligence. And the moment that he performs an arrest without having the proper authorization and documentation, well, now the crime of kidnapping has occurred, and it is a federal crime, Title 18, subsection 1201, because the victim is being held over for ransom in the form of bail. And anytime that you have a deprivation of rights under color of law that occurs in conjunction with the kidnapping, the punishment, as prescribed by law, is death. These are very, very serious offenses. And this is happening every single day all across Louisiana, all across the country. We need to get this addressed, because if our leaders, those that are leading our country, if they're criminals and they're transgressing the law, then they're going to lead us in the wrong direction. We don't want to go the direction the criminals are going, because that's going to produce a society of criminals. I, for one, am not going to be a criminal any longer, because I'm not going to follow them. So we need to decide, do we want to follow criminals? Do we want to obey them? Or do we want to step up and say, no, we're no longer going to follow you. You guys have no authority over us, because you guys are choosing to violate the law, the very law that gives you your right and your authority and creates your office. So right now, we're getting ready to go over to the Supreme Court. This is the Supreme, so we got to go over to New Orleans, and we're going to provide service on the Supreme Court of the state of Louisiana. We're going to ask them to step up, discharge the duties of their office, fulfill the promise they made to the people of the state of Louisiana, and hold criminals accountable for the crimes they commit against the people of the United States. If they choose to do nothing and remain negligent in this, then they will become complicit in the criminal conspiracy, because the laws of criminal conspiracy state any person who, having knowledge of any of the wrongs conspired to be done, and who have the power to prevent or aid in the prevention of the commission of same, neglects or refuses to do so, may be joined as defendants in the action. So once we provide notice to their agent, the clerk of court, we will provide a notice to the Supreme Court justices, because notice to agent is notice to principal. And once we notify them of the existence of criminal conspiracy, then they have a duty and responsibility to take action immediately. If they don't, they will be named as defendants in the action. We will bring them forward as we move forward. So today we're going to ask them to go ahead and discharge their duties of office, step up, do what they're constituted to do, they're obligated to do for the people of the state of Louisiana, and discharge their duties of office, hold criminals accountable for the crimes. Thank you so much. We're here in New Orleans at the Supreme Court of Louisiana, getting ready to provide service on behalf of the Cotton family. Cotton family here for the crimes of deprivation of rights under color law, conspiracy to deprive rights, kidnapping, and other crimes is ascertainable by the evidence on the record. When a state chooses to enact its own alternative legislation, substitute for the provisions and guarantees of the United States Constitution, that would be an act of sedition. When the state then directs one of its agents to enforce that law, that inferior law, and deprive a person of right guaranteed by the Constitution of the United States, that would be a crime. It is deprivation of rights under color law. Title 18, subsection 242, which states, any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any right secured by the Constitution, commits that crime. When that prosecutor then commits that crime and then hands that charging instrument that is incorrect off to the judicial officer, asks them to hold the person over for a trial, that judicial officer has a duty and responsibility to ensure that the power he exercises is consistent with his authority. If he chooses to exercise power based upon the prosecutor's abuse of power, then of course the power he exercises no power at all, and he has thus established a conspiracy by and between himself and the prosecuting attorney. So we're going to go into the Supreme Court here. We're going to provide service on the clerk of court. Notice to agent is notice to principal. We're going to let the Supreme Court justices know that what they are doing is illegal, and ask them to take action to enforce the laws of the United States, and get all the judicial officers within the state of Louisiana to abide by the obligations that are established and codified in the Constitution for the United States of America. So let's go do this. Hi, how are you?
Good, how are you?
Good. Are you one of the clerk of courts, deputy clerk of court?
I'm an assistant clerk.
Okay. So we have evidence for an ongoing federal litigation. We're at the United States Supreme Court. The state of Louisiana is not enjoined in it, but they need to be notified. And so we have evidence here that we need to provide notice to them.
Hold on, let me grab a deputy clerk.
Thank you. How you doing, brother? You a deputy clerk?
Yeah, I'm a deputy clerk here.
So we have ongoing federal litigation, the United States Supreme Court. State of Louisiana is not enjoined within it, but there are elements that Louisiana needs to be made aware of. So we have evidence here that we need to provide service to you guys. What we're needing is we need the justices to be informed of this, so that they can take corrective action and direct the judicial agents within the state to act in a legal and constitutional manner. That's hopefully, the resolution that we'll get from this. That's what we're hoping to seek, is without any further litigation. So front page here is the certificate of service. Just on the inside of the lip here is my contact information. You have one single criminal affidavit from one single affected party here within the state of Louisiana. Everything is very, very self-explanatory and very, very simple. I always handwrite all of my certificate of services, but when a state chooses to enact its own alternative legislation and substitutes it for the provisions and guarantees of the Constitution, that would be a crime. It's deprivation of rights under color law the moment that they direct one of the officers to enforce that inferior state law. So this is detailing that particular instance when it occurred.
Okay, hold on. I'm just trying to make sure I understand clearly what I have here in my hand. So it says here this is an affidavit for criminal conspiracy?
Yes.
Okay.
So when a state chooses to enact its own alternative legislation and substitutes it for the provisions and guarantees of the Constitution, that would be unlawful. So the Constitution of the United States states, Clause 1 of Amendment 5, that you cannot hold someone over for a capital or infamous crime without any indictment by a grand jury. Unfortunately, the state of Louisiana has enacted its own alternative legislation that permits the prosecuting attorneys to charge by information, not indictment, by their discretion. You cannot apply discretion with regard to one's obligations, especially constitutional obligations, because then you would be permitting them to be able to abuse their discretion to violate the law. So this is a very, very simple and detailed criminal conspiracy affidavit from, like I said, an affected party, someone that had this happen. When he was charged by information, not by indictment, as required by the Constitution, that was a crime. Title 18, subsection 242, deprivation of rights under the color of law, which states any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution, commits that crime. What we need is, we need the judicial officers, the justices here, that's in charge of all the judicial officers within the state, to recognize this and direct all the agents to act in a lawful and constitutional manner. That's why we're providing this service to you guys. So notice to agents, notice to principal. We have provided a notice to the Supreme Court with this. We need you to provide that criminal affidavit to them so that they can hopefully take corrective actions and direct all the judicial officers within the state to act in a lawful manner.
Okay. Okay. Well, I can certainly take this in.
Yes, sir.
And maybe possibly, because this is the first time I received something like this, so I'm not sure what.
Right. This doesn't happen very often.
RN.
Right. It doesn't happen very often, sir. Yeah.
Okay.
But what you need to understand, so once the prosecuting attorney chooses to rely upon the inferior state statute to deprive a person of right, and they commit that crime, the moment that they hand it to a judge, the judicial officer here in the state needs to recognize that they need to ensure the proper documentation is in place. They're not doing it. They're allowing the prosecutor to request the hold of the individual, or the arrest and hold, and the judicial officer is then at that moment establishing conspiracy to deprive of rights. That's Title 18, subsection 241. By and between himself and the prosecuting attorney. It doesn't matter whether he willfully did it or negligently did it, he did it because these are per se crimes. The moment that you have an obligation, it's constitutionally codified, and you fail to fulfill that obligation, that is a per se crime. You don't have to show that they intended to do it because their willfulness and knowledge derives from the promise they made. That's all detailed within there. The justices will understand completely what I'm saying. And hopefully we can get resolution without any further litigation that would be necessary with the state of Louisiana.
Okay. And you said your name was?
It's on the inside of the flap there, sir. All my contact information is right there. Tanawah Downing, sir.
Tanawah Downing, and said advocate Sue Jerez.
That's right.
Legal strategist.
That's right.
And you said you were
I'm the primary litigator on the federal court in the Supreme Court. I'll be litigating on behalf of the affected parties, Mr. Cotton as well.
Primary litigator at the United States Supreme Court.
That's right, yeah. And that's why we don't need a case here. We're not trying to open up a case because we've already got the case. We're just simply needing to enjoin the state of Louisiana, but we want to make sure that we give the justices plenty of time to take corrective action.
It was a United States Supreme Court case?
I guess, yeah.
Okay, give me 1 second. What is that?
Downing versus Washington.
Downing versus Washington.
I got, no, actually I don't.
And what is that court case number, please?
I don't have it off the top of my head, man.
Okay. Well, I mean, I got no problem taking this in,
Good.
so I'll discuss with our clerk of court what's the procedure for something like this.
Okay, awesome.
And you said this is your contact information. I can call this number.
You can contact me through that number or the email there, yeah. Anybody can contact me.
Okay.
All right. And we've already served all the attorney generals. We're now serving the judicial officers, so the state should be fully aware of what's going on. Okay? And your name is Ryan, is that correct, sir?
Yes, sir.
Okay. And you're deputy clerk. God bless. Thank you so much for your service. God bless. Thank you. Service has been provided on behalf of the Cotton family here in New Orleans at the Louisiana State Supreme Court for the crimes of deprivation of rights under the color of law, conspiracy to deprive of rights, kidnapping, and other crimes is ascertainable by the evidence on the record received by Clerk of Court Ryan Chan. Thank you. God bless.
But as it stands, all the problems that we can't let be, it's why divided we fall in. news without a poisonous agenda. I don't trust a politician.